This is for the people who are not too sure just yet, who are just trying things to see if it works, or you heard someone say something and you're carried away with it. This one is for you. Accepted for value was done in return for settlement. This was the man who invented this. This is the official court transcript, or the proceeding, and we'll show the transcript also. Accepted for value, return for settlement, exempt from levy, blah blah blah, all that good stuff, right? And this is the charges. This is the indictment right here that this was done. So he accepted the charges, the count and indictment for value, right? Meaning it was supposed to work, something was supposed to happen. Well, what happened next? They did a pre-trial proceeding. Now you see a lot of people pleading guilty to the facts and not the crime. There's a video that I did regarding a guy who did something similar like this, doing a accepted for value under conditions and pleading guilty to the fact and not the crime. We've already dealt with that flaw, meaning the fact is what determines the crime. So if you're pleading guilty to the fact, you're handcuffing yourself. You're already throwing yourself in jail and prison without them doing it. And here's an official court transcript of the proceeding right here of him doing that same thing, the man who invented this whole thing. So here's a pre-trial proceeding. The prosecutor read the charges. The judge said, "Thank you. In respect to those charges, do you wish to plead guilty or not?" And then he said, "On behalf of the defendant, I plead guilty." The acting judge said, "Say that again." He responded, "I said, on behalf of the defendant, I plead guilty to the fact." Remember, this whole pleading guilty to the fact, this is being done after he accepted the indictment for value, which is what a lot of people did, like the last video that I just showed. A lot of people mimic this. This is the guy who created all that accepted for value stuff now. By the way, this case is regarding failure to file a tax return. Then they go on and on and on and on. And then he asked the prosecutor that they put on the guy as a standby attorney. He said, "Well, can you repeat that for me?" And then, of course, the prosecutor, being a lawyer, would only incriminate him. He said, "I'm guilty of. I plead guilty to the facts." The guy said, "No, that's not what I said." The standby attorney said, "Oh, I'm sorry. I will refer to the court reporter." And then the court reporter read it, what he said: "On behalf of the defendant, I plead guilty to the fact." But guess how that acting judge interpreted it? He pled. Literally. The acting judge repeated these words, which is admissible as evidence according to rules of evidence. "I plead." You just pled. And he told him, "You pled guilty to the fact. The facts determine the claims that they're bringing against you." And the acting judge just pointed that out. He said, "Well," and then the guy said, "Just as she said." The court said, which is the acting judge, and whenever you see in transcript the court or in the rest of the CADAs or in the court decision, they say the court basically is referred to the acting judge. Because, well, that would make you guilty. Why? Because you pled to the fact. You pled guilty to the fact. That's the whole point of trial and pre-trial, to determine the fact. And you're willingly saying you're pleading guilty to it. Why? For what law says that? Why? Because it just sounds good. Somebody made that up. This is the guy who made it up right here, the defendant. Now you're doing the same thing, accepting for value, conditional acceptance. Come on now. The acting just said, "Well, that would make you guilty and subject to the penalties that have been set forth. And I take it then, you do not wish to go to trial on the fact. Is that correct? Because the trial is to test the sufficiency of the claim, to see if facts exist to support the suppositions." But he just willingly pled guilty to the facts. This is the guy that's teaching people these things. Then they went on and on. It got to a point where the acting judge realized, man, this man really doesn't know what he's doing. And he just got disrespectful. Watch. The acting judge, that is. Defendant, that's why I pled guilty to the fact. There have been no fact established in this matter yet, Your Honor. Well, in respect to this matter, yes, there have. There has been fact. And the fact is a supposition of that indictment itself, which is sufficient enough to state a claim if you don't rebut it into your affirmative defense. And accepting for value is not an affirmative defense. You've waived that right. You're doing something that's speculative, something that's a lay opinion, that's not an expert witness opinion. I mean, come on. And you expect that to be an affirmative defense? It's not. Rule 8 and Rule 12 lays out to you what an affirmative defense is in Federal Rules of Civil Procedure. He did none of that. He just wrote, except for value, return for settlement, which you will see a lot of people do. It does not work. Wake up. Be realistic. Well, in respect to this matter, he's pleading guilty to the fact, and the acting judge repeats it to him again. And do you have any basis? I'm confused as to what you want, because you could go to trial before a judge or a jury. You could be your own lawyer to the extent that we've talked about, and you wouldn't have to do anything. You'd have the power of the court to produce evidence. Look at that. Look at that. You would have the power of the court to produce evidence and witness. Evidence. You waive your right to produce evidence any moment you plead. We went over that before. And even worse, you're pleading guilty to the fact. The whole purpose of trial and due process is to determine the fact. And you're just waiving all that? Under what law? Under what rule that's in harmony with law? None. Just some speculation. Read this case. Read it. A lot of people mimic what this guy is doing. He got sentenced to jail for this case, off of doing accepted for value and pleading to the fact. He hung himself. You don't do that. Learn. What happened after this? He did I guess this was supposed to be a discovery, which is a kind of synonymous with interrogatory, which is a bill of particular. They did that, but they don't look at the title of the document. They look at the substance, because the title is just the form of it. Whatever is in the body is the substance of it. And then look at all this sovereign citizen stuff. They did all this, and then as a response, the matter is before the court to address defendant's document titled Plain Bar and Demand for Written Bill of Particular, True Bill in Commerce. A lot of people just love throwing this word commerce around. It's just a buzzword. It's just a trend. It's just fashion to people now. After careful review of the entire document, I am satisfied that it presents no legal issue to be resolved, because it raises nothing that can compel any actions. There's no law behind it, so there can be no operation of law to enforce anything. That's what the acting judge is saying. To the extent the document can be construed as a motion, meaning, well, whatever you put in, we can title all you want. We are considering a motion because you want us to move and make a decision, right? That's what a motion is. In order for us to be moved, it has to be a motion. So we'll construe it as such that we can make a decision. It is entirely lacking in merit and provides no basis upon which the defendant could be entitled to relief. Accordingly, the motion is denied.